Hello to our viewers, I'm Ezekiel Lepopani, a civil legal practitioner working for Legal Aid South Africa. Today we'll be discussing our right to housing. This is in terms of Section 26 of our Constitution. I'm with my colleague here, Janeski. So this is our 8th and final live broadcast focusing on women's rights this month. As we all know, the month of March is the Human Rights Month, and we are using this time to spread awareness to our human rights and answer any question that you may have regarding our rights. So you can leave comments or questions about human rights below. If you cannot respond today during this video, we look out for messages from us. If you require any legal advice, you can call our toll-free number. It's 0800-110-110. You can see it behind me here. Or you can send us a call back on this number. It's 079-835-7179, and we'll call you back. Like and share this video to spread the word regarding the human rights. So, as we know, the right to housing is one of the most important human rights that is recognized by our Constitution as well as the international human rights instrument and treaties. So our Constitution guarantees everyone with a right to housing. So I'll briefly discuss Section 26 of our Constitution. As you can see here, this section is divided into 3 subsections, but firstly, I will discuss the first 2 subsections. Then we'll finish with the last subsection, which is subsection 3. So section 26, subsection 1 of our Constitution provides as follows, that everyone has the right to adequate housing. What does this mean? Does it mean that the government must build houses for anyone, or you can decide as to where and how you want your house to be built? Then definitely no. So by the word access that is used in subsection 1, it simply means that the state must create a conducive condition to its citizens to access adequate housing. So, however, it also depends on the availability of the resources. We'll discuss that. So you will have to look again into subsection 2. Subsection 2 simply provides what we call a special limitation clause. So it doesn't mean that you can decide today and say, no, government must go and build me a house, or you can just go to the municipality and say, no, I want a house now. So there's that special limitation clause. We'll discuss it. So subsection 2 states that the state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right. So in other words, subsection 1 and 2 must be read together. So you cannot just focus only on subsection 1 and say, no, the Constitution guarantees you of the right to housing. You must also focus, you must also proceed to and look at subsection 2, which provides a special limitation. So we'll try to break down what does it mean by special limitation. So this section states that the state must take legislative and other measures. What does this mean really? So it means the state must establish what I can refer to as a coherent programs, which will be aimed at facilitating the realization of this right to housing. And secondly, the state must allocate responsibilities and tasks to different spheres of government. So by different spheres of government, it means your national, your provincial, and your local spheres of government. So they will be given tasks and responsibilities to ensure that this right is realized. So if you look again in subsection 2, it states that the state must take reasonable legislative and other measures within its available resources. So to to achieve the progressive realization of this right. So what does it mean by achieving the progressive realization of this right? It means, in a nutshell, that you can not just go to the your municipality, for example, and say you want a house now. No. It basically means tells us that this right it should be a continuous. It's a continuous process that must be undertaken by the government. So, however, the government is required to move more expeditiously and effectively as possible towards achieving this right. So, which means the state have that obligation to ensure that this right is realized expeditiously so and effectively so. So another thing that we can look into in terms of the subsection 2 is what does it mean by within its available resources? So it tells us that for this right to be realized, so it will depend on the available resources. So if there's no available resources, obviously the government won't provide that houses. So that's it. So the government is also taken, we know that there are legislations that regulate or that were enacted to give effect to Section 26 of our Constitution. I'll briefly touch on those acts. The first one that we know is the Housing Act 107 of 1997, the Rental Housing Act of 1999, and the Social Housing Act of 2008. So the most important piece of legislation with regard to housing programs is your Housing Act of 1997. So this act lays down the general principle for housing development in all spheres of government. As I've already indicated, the spheres of government, it refers to your national, your provincial, and your local government. So this act also defines the function of the housing development and lays down the basis for financing national housing programs. So such as your RDP programs and so forth. So this act also put an obligation in all spheres of government to give priority to the needs of the poor in respect of housing development. So this tells us that the government must firstly focus on the poor. So they must prioritize the poor. And then they have to consult meaningfully with individuals and communities that are affected by this housing development. So obviously priority will be given to the poor. So that's it. So another provision that was important provision that was brought in by the Housing Act is the issue of state subsidized houses and service site that you cannot alienate or maybe sell the state subsidized house or service site within a period of 8 years from the date in which that property was acquired. So I think that is one of the important provisions that was brought in by this act. So another act that I will briefly touch is your Rental Housing Act. So the Rental Housing Act is a piece of legislation that regulates the relationship between the landlord and the tenant in the rental housing. So which means it's only for residential dwelling. So this act also places an obligation on the state. It states that the government must assist in introducing incentives or mechanisms and other measures that will assist in improving the conditions in the rental housing market. So it also encouraged government to assist in ensuring that there's investment in both urban and rural areas regarding the rental housing. It's also it tells us the government must assist in facilitating the provision of the rental housing in partnership with the private sector. So I think we've seen that happening in most part of our country. So another important provisions that was brought in by the Housing Act is the establishment of the Provincial Housing Tribunal to resolve the dispute between the landlord and the tenants concerning unfair practices. So these the tribunals, they are independent body. So their main aim, their main purpose is to regulate or to resolve the dispute between the landlord and the tenants only in residential dwellings, which means commercial lease and so forth, that they won't be covered by the, you cannot refer that dispute to the rental housing tribunal. It's only for residential dwelling. So the rental housing tribunal has the powers to can summon both the tenant and the landlord to can appear before it for mediation or tribunal hearing, only in case there is an unfair practices on behalf of the landlord, or maybe there's a problem with your tenant, then you can refer your dispute, then they will assist you. So the tribunal, the ruling made by the tribunal has the same power as the judgment of the magistrate court. So I think that is very important as well to note. So what do we mean by unfair practices? So unfair practices can, it can be, for example, if your landlord is refusing to refund your deposit. So that you can refer that to the rental housing tribunal, or there's an overcrowding. Maybe the landlord is overcrowding the place you're renting, then you can refer that to the rental housing tribunal for assistance. Or there's it can be your invasion of your privacy as a tenant. You can refer that to the tribunal. Unlawful seizure of tenant's goods. If the landlord just comes to your place and take your goods without the court order, that can be referred to the tribunal for assistance. Failure to issue a receipt. If the landlord maybe is not giving a receipt after payment, and next time he comes back and demand more payment, then you can still refer that to the tribunal as well. Or maybe the intimidation is intimidating you, the tribunal can cover that as well. Or maybe if you have a tenant who's behaving in an undesirable manner, it will be covered as well. Other thing that can be referred there is your non-payment of rent. If your landlord, your tenant is not paying rent, that matter can be referred to the rental housing tribunal. Lack of maintenance or repairs. If your landlord is not maintaining or repairing the property staying in, then you can refer that to the tribunal. Illegal eviction. When coming to legal, maybe you arrive back from your work and you find that your goods are thrown all over the place, then you can refer that to the tribunal for assistance. Remember, they have powers to issue what you call the spoliation order. So illegal lockouts is also that those can be referred to the tribunal, or illegal disconnection of services. Maybe the landlord decide to cut your water supply or electricity, then you can refer that to the tribunal. Unacceptable living conditions. Yes, you can refer that as well. Excessive rental increase. If maybe the landlord just decide to increase your rent excessively, so at 50%, 60%, then you can refer that to the tribunal. Okay. So the last section that I want us to look at is section 26, subsection 3. Subsection 3 of our 26 subsection 3 of our question prohibits what we call eviction of person from their home or demolition of their home without the court order. So which means the landlord cannot just come and evict you, or any person cannot just come and evict you from your home without the order of the court. So they must firstly make an application to court for an order. If there's no court order, then that eviction will be unlawful. So section 26, subsection 3 provides that no one may be evicted from their home or have their home demolished without the order of the court, made after considering all the relevant circumstances, and no legislation may permit arbitrary evictions. Eviction. So, which means for one to can be evicted, the owner must firstly make an application to court for an eviction order. So there are a few legislation that were enacted by the Parliament to give effect to the provisions of Section 26, Subsection 3. So the first one is the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act of 1998. We also have what we call the Land Reform Act of 1996. So the purpose of the land reform is to protect the labor tenants. So for more information regarding what is meant by the labor tenants and so forth, you can maybe contact our call center. So we have also what you call the Extension of Security of Tenure Act of 1927. The main purpose of this act is to protect occupiers of farmland. So these were the act that, legislations that were enacted by our legislators in ensuring that the provisions of Section 26, Subsection 3 of our Constitution are protected and realized. Thanks for joining us. If you have any further questions, you can send us a Facebook message, or if you require legal advice, you can call our toll-free number on 0800-1110-110, weekdays between 7 a.m. to 7 p.m. If you cannot call, you can still send us call me back on this number 079-835-7179. We'll definitely call you back. We hope you have enjoyed these Facebook Live videos. Look out for more in the not so distant future. Thank you. Bye.